Hello, everyone. My name is Imran Ahmad. I'm a partner here at Norton Rose Fulbright Canada, and I'm delighted to have my very good colleague, Suzie Suliman from our technology group, join us today. We're going to be doing these technology and privacy primers as we've been doing over the past few months. And Suzie, in particular, is going to be talking a lot about technological development. So I think you'll find it very topical and interesting in terms of what she's going to be covering over the next few months. But today's session is going to be on DPAs or data processing agreements, which is a hot area and has been a hot area for a few years. Many of us are seeing this post GDPR, DPAs being presented to clients and being asked to sign them, not really understanding what is standard, what is nice to have. And what we're hoping to do is sort of untangle all of that with you today, Suzie. And so, Suzie, I'll just jump right into it and maybe ask you a first question. From your perspective, why should organizations have data protection agreements in place with their service providers? Is this a nice to have, or is this something that is essential when you're looking at service providers and the agreements you have with them?
That's a great question, Imran. Lots of companies are engaging third-party service providers to conduct certain activities on their behalf. For example, they may have a third-party service provider do their payroll for them or their IT, store data for them, or send targeted advertising to their customers. And as we know, under Canadian privacy legislation, the definition of personal information is quite broad. It includes anything about an identifiable individual, which can be their name, their contact information, their shopping habits, their salary, their banking information, pretty much everything under the sun. And so when an organization provides personal information about their customers or their employees or what have you to a third-party service provider, the organization remains responsible for what happens to that personal information. So for example, if you are an organization that puts your data on the cloud that's operated by a third-party service provider, and that third-party service provider has a data breach, it's the organization itself that has privacy obligations to notify affected individuals and report to the regulator, and not necessarily that third-party service provider. So the DPA imposes obligations on that service provider to meet certain privacy protection requirements, and it helps the organization meet its own obligations under applicable privacy law. So essentially, it's not really a nice to have, it's more of an essential thing that lots of organizations should be thinking about. And just to give you an idea of what the consequences could be of not meeting appropriate privacy obligations, if your third-party service provider does something to cause you to breach your privacy obligations under applicable law, under PIPEDA, those fines could reach as high as $100,000 per violation.
So that's really interesting, Suzie. Let me talk about how you structure these agreements. So are these DPAs part of a standard service agreement? Are they standalone documents you present to your clients? How does that work exactly?
Yeah, so the DPA can be part of a service agreement. It can be attached as an addendum, which we see pretty commonly, or those obligations can be built into the body of the agreement itself. As a best practice, you'd want to have those in place at the time that you sign the original service agreement, and especially before any services are provided. However, if you've already entered into a service agreement with a service provider and there aren't appropriate protections in place, you can always enter into it later on and attach it to the original service agreement, as long as it's all done correctly.
Right. So let me ask you the question: when you're drafting these DPAs and you're looking at what goes in scope and what's outside of scope, how do you determine that? What factors go into it from your perspective?
Yeah, the DPA should take into account the sensitivity of the information that's being shared. I talked at the beginning a lot about personal information, but you also want to think about proprietary and confidential information as well. Because if proprietary or confidential information about the business is exposed, there could be significant financial harms to the organization. And you'll want to think about how sensitive that information is. For example, if you're sharing health information or payroll information with a third party, that's a lot more sensitive and probably requires more obligations or more stringent obligations than if you're just sharing maybe names and email addresses with a company. The definition of personal information or company data, or similar terminology that you use in the contract, should appropriately capture the nature of that relationship between the parties and the information that the service provider will receive. And it should also take into account any sector-specific definitions that might apply as well. And not only do you want to take into account the sensitivity of the information, but also what privacy laws may be at play. For example, where an individual resides can add additional obligations into the relationship, such as an obligation to notify individuals if their data is going to be transferred to other jurisdictions. So if your service provider is going to be transferring data, you'll want to know that.
Right, very good. So let's talk about some of the details of what goes into the DPA in more granularity. So can you talk about some of the common obligations that service providers will agree to under a DPA, and more importantly, common restrictions that may be imposed upon them as well from a service purchaser perspective?
For sure. Some of the common obligations we would impose on a service provider in a DPA would be obligations to comply with applicable law and regulations, to use data only in accordance with the organization's instructions, to limit disclosure of that data, to take appropriate security measures to protect it, and to not use the data for any purpose beyond that explicitly permitted, whether it's commercial or not. There may be other obligations, but it'll really depend on the circumstances. But those are kind of the most common ones.
Right. That all makes sense, Suzie. But let me ask you, why is it so critical to sort of control the purpose for which the service provider can potentially use the data or process the data? Does it really matter?
Yes, it does. So under privacy law, and when it comes to personal information, an organization has an obligation to identify to that individual the purpose for which their personal information is going to be used, and to obtain the individual's informed consent for collection, use, and disclosure of that information. So in an organization that has collected information needs to ensure that it's not being used for new purposes beyond those for which the individual provided consent. And so a lot of service providers now include certain rights in their standard terms of service or their agreements that allow them to use an organization's information for data analytics or other business purposes. And even if that information is de-identified, it could still be subject to privacy laws. So if you're granting permission to your service provider to use that information for other purposes, you'll need to ensure you have sufficient consents from your customers or employees or whatever the data subjects are for their information to be used in that way. Otherwise, your organization could be in breach of your own privacy obligations.
Right. All good points. And there's a big debate around data anonymization, de-identification of data, which one is still within scope of privacy and which one isn't. And maybe just a hint to our viewers, anonymization, you're out. De-identification, you may still be in the government of privacy legislation. So let's talk about something which is near and dear to my heart, which is security. Cyber is an area that I track very carefully. Can you talk about some of the obligations that are imposed on service providers when you're looking at DPAs? How detailed do they need to be, or granular, because security changes and hackers are very sophisticated? Any thoughts on that?
For sure. I mean, you say this all the time, Imran. It's no longer if a security incident happens, it's really when. And every organization needs to employ security measures to protect personal or proprietary information that they have. And that those measures can really depend on the sensitivity of the information. They do need to be appropriate based on how sensitive the information is. But if that information is disclosed in some unauthorized manner, if it's proprietary information, you could risk losing the value of that information, which could have significant impacts for your business. Or if it's personal information, you may end up having to notify a bunch of individuals and report to the regulator. There may be costs and reputational harms that are associated with that. And not only is it important that the service provider take steps to secure that information, but it's also important in your DPAs to have an obligation on your service provider to promptly notify you if there's been a security breach. Because otherwise, you may have no way of knowing that a security breach has happened, and as a result, that a privacy breach has happened. And if you are unaware of that and you don't meet your own obligations, as I said, those notification and reporting obligations, you could be in breach of your obligations under privacy law. And as I noted, there are fines and investigations that could result. And then in addition, those obligations should ideally require your service provider to notify you as quickly as possible. A lot of times you'll see them say once the privacy breach is confirmed, and that might not always be sufficient. You may want to know as soon as a security incident is reasonably suspected so that you can take some steps to mitigate those harms.
So that's a lot of risk, and it can be challenging, and in some cases maybe even overwhelming how to manage that risk. Any thoughts or ideas about how you can identify which risks are critical, which ones are less so, and how do you manage sort of in terms of tiering or triaging those? I know that always comes up in your conversations when you're talking about DPAs with customers and clients.
For sure. I mean, I think there are lots of harms that could result, the big one being the financial harms if it's your proprietary information, and regulatory fines, penalties, the costs of having to notify and report, and all of that. I think there may be reputational harms as well. I think it's really important to think about what information you're sharing with your service providers and what the risks are if that gets out into the wrong hands. Your DPA can help mitigate some of those risks. So you can require your service provider to have sufficient insurance, whether it be commercial general liability insurance or cybersecurity insurance, as appropriate and with limits that are appropriate for the harm that you foresee could result. And in addition, you could have obligations on your service provider to indemnify you and hold your organization harmless for any costs or expenses that may result from their misuse, destruction, loss, or unlawful disclosure of the data. And you would want those indemnity obligations to survive any relationship between the parties. And finally, I think another way that you can mitigate those risks is to ensure that information is properly destroyed or returned at the end of that engagement to make sure that, it's not sitting around when it doesn't need to be.
Susie, you raised some fantastic points. We could do another hour with you in terms of DPA. So I think the audience found this super informative. Thank you for being so concise and sharing your insights. I just remind our audience every month, Susie is going to be joining us to share her technology law tips, both in terms of commercial contracting, M&A, transactional, and the emerging technology area as well. So looking forward to those conversations. In the meanwhile, if you have any questions, please reach out to Susie or myself. We'd be happy to answer any questions. For those who are tracking our blog, make sure you sign up for it. There's content from around the world and including Canada, which is super helpful that may be of interest to you. Susie, thank you so much. We'll connect with you again next month.
Thank you. Happy to be here.
Bye for now.